Hi, everyone. I'm immigration lawyer John Khosravi. It's March 24, 2021, and we're going live with our traditional Q&A that we do to discuss U.S. immigration. I'm just getting set up here as people start trickling in. Let me turn on some lighting, see if this helps any. There we go. Got a real close-up of me, too, to get to know me pretty better. So, everyone, I'm immigration lawyer. We're going to go do our regular live, taking your questions on TikTok, on Facebook, on LinkedIn, on everywhere on the internet except for Instagram. I'm not doing that one live, but just shoot out there. The immigration situation is not good. I mean, there's stuff you're hearing at the border, which is horrible stories. I'm not going to get into that here. It's more just active cases and to give you general educational advice. But the situation has got horrendous when it comes to timelines and delays and non-movement. Now, the cases are moving. This week, I had a lot of marriage, green card interviews. I was actually going to the USCIS field office and doing these interviews, and that was happening. But embassies are not happening. Other cases are being delayed drastically. So this is all stuff that we're going to have to deal with, and we're going to talk about right now. Let's do it. All right. Once again, thank you for joining us. This is John Khosravi. We're going to do U.S. immigration questions live, and it is March 24th. Feel free to shoot out your questions, and we'll answer them. In the meantime, let me talk about the updates. One is that the public charge rule is gone, and so that's a positive thing. I mean, the rule is not gone itself; it's still there. But what has changed is the aspect that the form I-944, the public charge thing, what is it called? A declaration of self-sufficiency is not an issue anymore, and so that's one positive thing. But the general public charge rule of having an affidavit of support, that is still there. Now, if you're watching live on YouTube, you might be seeing my forehead disappearing because of the green light. I see it myself. Hopefully that changes, but we'll just go live with that. Not everyone's seen it on TikTok. They won't see it like that, but I'll just keep there. We'll have an edited video, fix that all up when the time comes. Okay, so that's the situation with public charge rule. That's good news. The bad news is delays are still happening when it comes to biometrics. That's not coming up. When it comes to receipts, that's still not coming up. And so we're dealing with this kind of crazy situation where, no biometrics are there. And so what are you going to do? You just have to wait for them to come. It's very hard to get it expedited because there's not that much of a reason. The embassies are shutting down. Just got word that the Emirate of Abu Dhabi in the United Arab Emirates is not allowing non-residents to enter there. Well, the U.S. Embassy for granting green cards in that area is right there. So if you can't go to your interview, you can enter that emirate, that area, then you can't go to interview. So that's a massive, massive situation that popped up. Now we have a question from 10RGS. My I-485 is pending for the last 145 days, no biometrics. Is it safe to file I-485 with others? Is it safe? Well, that's a really complex question because I-485J is if you are porting jobs. What 145 days is not enough. You have to wait 180 days after filing the I-485 pending to be able to change jobs if your goal is to port. Is it safe? Contacted your own immigration attorney, talk about them. You got to look over your I-140, your I-485 receipts, applications. The biometrics itself doesn't matter for I-485J. That's not related, but 145 days is not enough time to port. So you have to have the case pending for a longer time. So I would say schedule a private consultation to see what's going on in your case. We can do a video on my office and figure out what's going on. I may need to talk to the new employer too if there's more stuff to do, but that's something I would think about. Now, Jordan asks, does my USA spouse have to be working to sponsor my green card? Well, as I talked about earlier, there is an affidavit of support requirement. And part of that requirement is that you have a U.S. sponsor that could, support you financially. Now, your wife traditionally would be the sponsor, the U.S. petitioner, but if she doesn't work, if she's not making money, you can use assets potentially, like money you have saved up for property, or more likely you bring in a joint sponsor. It's another person that's a green card holder or a U.S. citizen that says, I'll financially support you if needed, and submit Form I864 affidavit support as a joint sponsor to cover that situation. So it's really important for you to get that if your wife doesn't make enough money, because they won't approve it if she's not working or doesn't have, or you both, either of you don't have a lot of savings to be able to satisfy that requirement. Fatima asks, can we apply for H-1 from two different employers? Well, they said that in the new H-1B registration session, I assume you mean H-1B, that you can't do two different employers. Generally, you can have two H-1Bs from two different employers, but the registration system, they said, is only for one. One of my colleagues handles H-1B cases, not something I do on a regular basis. And so if you want to set a consultation to discuss that further with the employer, then you could connect with my colleague. Just email me. But one thing important to note is the employer is the person paying and filing for the case, and they would have their lawyers who can answer this question. So you can have two H-1Bs, working part-time at two, rarely done. But for the registration system, they said if you're doing duplicates, they may check out both. So I would be careful, but talk with your employer's immigration lawyer. H-1B is not something I do. My colleague handles those. That girl asked, hello, if they send us a notice about adding an I-944, but we are now seeing it's not required, what should we do? Well, the rule is you don't have to do anything. But what I've been doing in those kind of cases is I've been responding to the request for evidence, which is including a copy of the request for evidence, mailing it to location, but also a printout of the website page on USCIS.gov that says the I-944 declaration of self-sufficiency for the public charge is now required. So at least goes in the system, because it's not unheard of for USCIS to mistakenly deny a case, even though they're not supposed to. So the safe thing as an attorney, what I would do, and I'm doing for my case, is notifying them that, hey, here's the RFE. Please remember, don't mistakenly deny this case. We're not required to submit this I-944. So that's something we would do, but be careful. Read the request for evidence notice, the RFE notice that they sent you for that, and make sure they didn't ask for other stuff. They may have said submit form I-944, which is not required, so you technically don't have to respond. But then they may have added, hey, you didn't send your right birth certificate, or missing a marriage certificate, or something like that. You don't want to miss the other part. So make sure you read the whole thing and you're not missing something in particular that could be problematic. Kishore asked, I have filed my I-485 to green card for employment base and the date is current. I gave my biometrics. Can I submit medical without RFE? Please advise. No, it is not recommended to submit your medical checkup without an RFE requesting it. You usually want to wait for the government to request it. It might get have issues. So I would not do that. I would definitely wait for them to request it. It kind of causes delays. That kind of sucks, but whatever, you just got to wait it out. But it's not good practice to mail in something without them requesting it. A user blank says, hi, sir, I was arrested in 2020, domestic violence. Is it affecting my citizenship application? Yeah, it could. But there's a lot that has to be talked about there. So you have to see what the court situation is, if you're guilty or innocent, if you're convicted, what the facts of it were. But it can affect your it could even affect your green card. If it's really serious, you get your green card taken away. So you really need to contact an immigration attorney and talk to them in private, see the records, don't plead to anything yet before talking to both the criminal attorney and an immigration attorney. It's very, very, very serious situation that you're in. Anil asked, I got an RFE on I864, that's the affidavit support, where I can see income on Form 1040. So for the affidavit support, when you're doing a family-based case, and sometimes other cases, primarily family-based cases, you have to submit Form I864. On Form I864, it asks for your total income listed on your tax returns for the last 3 years. If you're doing a 1040 IRS tax form, if you're using tax form 1040 easy, use adjusted income. So generally, people just use the regular 1040 form. You'll find it on usually the first page in the area where it says total income. That's the number you put in as the income in the tax portion of 1040. Now you're seeing there's other areas of the I-864 form. I need to see exactly what you're doing in your tax return to advise exactly what's going on in your case. If you're having difficulty with that, I recommend just consulting with the immigration attorney, review your documents and the paperwork. But that's the proper full answer. But again, every case is different. We got to see what's going on in your specific paperwork. Kishore says, thank you very much for your help. God bless you. Thank you, Kishore. I hope that information helped and get you where you need to go. Christopher asks, what to do if we live separately due to school stuff and don't travel a lot because of COVID? Well, assuming you're talking about a marriage case and you're not living with your spouse, what are you going to do? Well, it depends on the facts and circumstances. If you could show that, you're going to school one area of the country, the other, and you have to go to classes, so you can't be, together, you can't live together, you explain that and you try to document in other ways. Now, if you don't have joint travel together, that's not good, but, you've been dating probably each other, you've known each other. There's letters from family and friends, there's old photos, there's communication records, WhatsApp records, text messages. There's a lot of different things you could do. You just got to dive down and see what's going on in your relationship and how you guys are together, and then, figure it out. Or just better yet, just consult an immigration attorney so it can help you go through that. But it's still possible, but it depends on the facts of your case. That girl follows up, when they ask if we are exempt from public charge of inadmissibility, what do they mean? So for Form I864, there are certain exemptions. There are certain people that, although everyone else in that category of family-based cases has to submit Form I864, they don't, and those are exempt. That's typically a person who's worked in the United States for 40 quarters. So what is that, like on 8 years of working in the US and getting paying for Social Security, all that kind of stuff. There are people who are like children of US citizens who don't automatically get citizenship, who have to apply for a green card first, and upon entering the United States, automatically US citizenship. Those are exempt from the I-864 as well. Asylees and people on certain humanitarian cases are exempt from the Form I-864 as well. So that's what they mean by being exempt from the public charge rule of admissibility for those categories, specifically on the I-485 adjustment of status application. A human being. Now, everyone's subject to public charge except asylees. So, but what I was discussing are exemptions to the Form I-864. But you could still be subject to public charge in the other categories, but it does exempt you from Form I-864 if you're other than the asylee category, the other versions I mentioned. A human being 8 asks, my pending I-485, it's a green card application, I-824. That's when you have a family member outside the United States and you want them to get a green card too, follow to join. Can I apply for a student visa for my daughter? Does it affect the I-824? Well, you could try applying for the student visa for your daughter, even though she has essentially a green card case pending. The embassy may deny the case, saying the person has the intent to come to the United States and get a green card. And so that's immigrant intent. You can't ask for a non-immigrant visa, a temporary visa, for a visit to the United States, like a student visa, and then come back and say, oh, they may come back and say you're also going to live there and not come back. So they may or may not do it, but if you want to give it a shot, then give it a shot. It's up to the embassy if they do it. It's very hard to get an appointment right now for an embassy, but if that's, if she wants to come to school study in the U.S., then give it a shot. Letitia asks, my husband recently was denied his visa because he believed he'd be a public charge in Nigeria. I make over the amount for 3 people now. I do not know what he can do. Do we have to start over again? Well, the embassy would give you a letter if they denied your case for public charge. And typically they'll come back and say, you have one opportunity, you have an opportunity to get more paperwork or what the deficiency was and do it again. So I'd have to see what the embassy said in your case in that letter that they gave your husband after his interview, and may be able to get a joint sponsor or other ways to show income. But if they full on deny the case, then yeah, you'll need to resubmit. But I would need to see the actual paperwork in a case to see what happened. Ammo asks, can I file an H4 with an H1, or I need to get the H1 approved first? When you file for an H1, you could usually, for these kind of cases, a change of status, you could file for the derivative too, so it's approved at the together. They don't approve them together, but they'll be pending together. I spoke as earlier. I don't typically do H1Bs anymore. My colleague does, so I would need to have a consultation situation with them. But I believe you can, but I can't guarantee that. I haven't done this scenario in a while. But usually when you have an H1, the principal applicant could have a derivative, file the I-539 with it, so they're both in the system together. The H1 will probably get approved first now with the backlogs, but that should be possible. But talk with your employer's attorney, because usually your employer will hire an attorney and they'll know exactly what to do there. Mrs. G8 asks, are they issuing married visas, U.S. citizens, for people from Brazil? Because if a spouse isn't allowed to travel straight there, why would they not issue the visa? Because travel, it makes no sense. Okay, so your question is not word the best, but are they issuing green cards, immigrant visas for green card for spouse of U.S. citizens in Brazil? First of all, there is an exception to the travel ban that Brazil has for COVID for people that are married to U.S. citizens. So there's no travel ban for your spouse, and so they can schedule an interview. Now, Brazil, each embassy, because of COVID situations, are either closed or they're processing cases in much fewer numbers. So you'll probably be able to get immigrant visa, but huge delays to get it, and that's the situation with that. Fatima asks, I want to file for divorce, but my ex-husband is not here, hence he won't be able to come to court. Well, I'm not a family attorney. You should contact a divorce attorney in your state to advise on this. But if, typically a court case, whether it's divorce or any other kind of court case, the person's not there, and this U.S., you could find ways of giving them service so they get notification and do an in absentia or some sort of order like that. Just talk with the divorce attorney in your state. That's the appropriate thing to do here. It is possible to get divorced if your spouse isn't here. But again, talk with the divorce attorney in your state. Sriracha asks, hi, I'm happy to announce I passed my naturalization interview and attended my oath ceremony last week. God bless you. Thank you. And you say, thank you for all your help and answers. Helps a lot. Is there a way to get the U.S. passport faster if we have to travel? Well, Sriracha, congratulations on becoming U.S. citizen. Thank you for the kind words. If you can, type in JQK Law Firm and leave a review for my my law firm if I was helpful. I really appreciate that. Can you get the passport faster? One is the passport office in the United States is super backed up. So typically no. But you contact your local passport office, you show that you have travel plan, and you ask them, and it's in their discretion to give an expedite there. So it just really depends on what evidence you have of the need for you to travel, and the luck you have which officer is going to listen to you and want to do it or not. So you got to go online, find the local passport office, not the post office that does it typically, but the U.S. Fed is usually in a federal building that's closest to you. And call them up or go in person and see if they'll grant you an expedited one. If not, it's going to take 6 to 8 weeks. Make sure to do the paperwork right. That could be a problem sometimes, cause delays. Ambrose says, hi, John. Would you qualify as a joint sponsor for this affidavit of support? My married U.S. citizen sister filed a petition for me way back in 1995. Our priority date has been current for a couple of years now. Well, there's a couple issues right there. Who would qualify as a joint sponsor? Anyone that wants to become a joint sponsor qualifies, as long as they're a U.S. citizen or green card holder and they make enough money. But the issue is, if you've been current for a couple of years now, the National Visa Center would have contacted you to say, hey, start your case. And if you didn't respond to that within a year, they did cancel your case. So hopefully you've been following up every year and telling the National Visa Center, hey, we're going to continue the case, just not now, but please keep our case open every year, emailing them or calling them. And so make sure they don't cancel your case and delete it from the system, because if they do, you're going to have to wait 15, 20 years all over again. So hopefully that's not happened. Hopefully you've been on top of it, Ambrose. But affidavit of support sponsor, anyone who makes enough money as a U.S. citizen, green card holder. That's the larger picture. But I would need to review their documents and make sure. Like, one problem I have with people, they'll have businesses and then business makes a lot of money. But for tax purposes, the way they do it, they personally don't make enough income. But the business keeps the money. It's a tactic for taxes. I don't know if it's correct or not. I'm not an accountant. But then they come to me and say, oh, I make a lot of money. And then I get their tax return and they don't make any money. And now they do make money, but it's a tax tactic. And I tell them, well, we can't use it. So I really need to review the tax returns of the person as joint sponsor, review their background, do all this kind of stuff to be able to tell you. But the basic of it is, if they make more than the minimum amount for the family size that's required, and they're U.S. citizen, green card holder, it should be possible. Leroy asks, my fiance is from Nicaragua. She is currently in Costa Rica without a visa. Can we marry in Costa Rica while she is there without a visa and file the I-130 while she is out of her home country? Well, there's two questions there. Can you get married in Costa Rica at all? And you know what? I'm not a Costa Rican attorney. I don't know what the rules are there on people getting married if they're there. So I can't answer that. Contact an attorney in Costa Rica that does family law or something. But with regards to the I-130, yeah, it doesn't matter where she is. You could file the I-130 as long as you're married. I-130 is a petition for alien relative for when you want to bring a spouse over, or different kinds of family members. Paranoid Joy to regular asks, can I change status from an F1 OPT to an O1 without leaving the U.S. and start working if I qualify, or do I have to leave to get a visa? No, you could stay in the United States, change the status from an F1 to an OPT to O1 for an I-129. You need an agent or a petitioner that's special for the O1. You have to satisfy the O1 requirements, but it's possible. I have a colleague that does these business cases now, H-1Bs, O1 stuff. Just schedule a consultation, email my office, and I could connect you with them. There's a consultation fee. Include a copy of your resume, your background, and you connect with them to see if you have good O1 case, but it's possible to do change of status in that way. That girl follows us up saying thank you. God bless you, that girl. Thank you for coming on the show. Reddy asks, I got my interview scheduled, but I haven't received my EAD. Is that a problem? No, sometimes the EADs take longer than the appointment being scheduled for your green card. You may not even get an EAD at this point, but there's delays in getting the EAD or the work permit. That happens. Now, we have a lot of questions about timelines and embassy operations that I said several times, and I say every time, is I have no power to judge the future, so I can't tell you how long these cases are going to take or when the embassy opens operations. Only God knows that. And so pray, and hopefully in your prayers they'll tell you, but I'm not God, so I can't answer that question. How long, why is this taking this long? These government agencies take a long time, and so I don't have control. Only thing I say is be patient. If it's a ridiculous amount of wait, maybe you could sue them, but it depends on the case and how long the wait is and what the reason for the wait is, all this kind of stuff. But, COVID-19 is happening. USCIS is essentially a bankrupt agency. They're getting bailouts. So, this stuff's going to happen. Jing asks, Rose, hi, my son's I-130 was approved, and since we aren't his parents in his birth certificate, we provided a DNA and it was approved. Will the embassy look for the birth certificate where we appear as his parents, even if we have the DNA? Thanks. Well, we'll see if it's been approved, the I-130, they already have it in the system that they recognize your DNA if the government ordered your DNA, so it's there. But the embassy could do whatever it wants. You have to be able to show what's going on. Even if you have DNA, many times they'll say you have to have a relationship with the child to do an I-130 for him. But it depends. I'd have to review the case, and it depends on what the embassy asks. They could do whatever they want. Letitia follows up. Thank you for all you do. Thank you, Letitia. It's very kind of you. Fatima says, thank you. God bless you. Dara Tango sent a like to host. Thank you, Dara Tango. I appreciate that. Trent asks, can an F4 category apply for a foreign visa, visitor visa? Well, it's a really important question that you hear a lot of conflicting information on. An F4 preference category is a brother and sister of a U.S. citizen, a sibling of a U.S. citizen. That's when you have a U.S. citizen person applying for a green card for their brother or sister. Process could take 10 to 20 years. In the meantime, can that brother or sister get a U.S. tourist visa to come and visit and enter here? Well, the answer is, it's possible. It's in the discretion of the U.S. Embassy or consulate issuing the visa, and at the border inspector, CBP, Customs Border Protection, that's at the border, whether they'll let you give you the visa or let you in. So it really depends on your background. Their fear is that you're going to come to the United States and not leave and go back to your home country to get the green card later. So if they have that fear, yeah, they could deny you visa or entry. But if, for example, you have work back home investments and a return ticket, all this kind of stuff, they could issue the visa and allow you in. So can they apply for visitor visa? 100% you can apply. Will it be approved? Maybe, maybe not. Depends on your case and what the officer that day at the embassy wants to do. It's all discretionary. There's no it's no science, so it's all discretion, whatever they want to do. Google asks, I'm applying for an EB3. That's an employment-based third category green card. The LC should be done in April. What's the moment during the process I can include my wife? And what's the extra form fees I need to pay to include her in the process? Thanks, John. Well, the form fees itself, your wife will have to file for home adjustment of status from I-485. Right now, it's $1,225 for that. When can you file for that? When you're at the point where you need to file for I-485. So that's it. So it depends on what country you're from, what your priority date is. I need to know a lot more information, Percio. Ask the employer the attorney for your employer, or schedule a private consultation. Google, but yeah, you just gotta wait, and when that happens, it happens. When you're filing your own I-485, you want to include one for your wife as well, along with the advanced parole and EAD, and that should take care of it. And that girl asks, hello again. My mom got sent a notice and was told to resend her documents. I am a stepchild. When she is resending, could she resend it with my petition? Also, will they accept? Well, I lost track of what your previous question was. But if a U.S. citizen is applying for a child, they have to send us one petition, one application for that specific child. You don't come in on the other person. Now, if your step parent was a green card holder, you'd be included on the mom's case with USCIS. But if it was a U.S. citizen step parent that married your mom before you were 18, then they have to do an individual application for you. Paranoid Joy says, thank you, sir. You're welcome. God bless you. Rocky asks, how to withdraw asylum case and go back to home country, how long it takes, and can you help? And you sent likes. Well, Rocky, if you want to withdraw your case, if that's appropriate, I would need to have a consultation, review the facts if it's appropriate or not. But you just send a letter to a local asylum office, or just leave. It doesn't really matter. It's going to be hard for you to come back to the United States in general. But one thing is, you don't want to be accused of filing a false asylum claim. That's going to make it almost impossible to come ever to the United States. Fredlin asks, hello, my husband sent an I-751, but it was rejected because of missing pages. I-751 is if you've been married and your green card is only 2 years and you want to get a full 10-year green card, you have to file this form to be able to show your relationship is real. It was rejected because there are missing pages in there. The return package and the rejection letter was never sent to us. He resubmitted it. Will affect his NSM1 process. No, it shouldn't. Hopefully get it in time and you get the receipt. There's delays in getting receipt, but just because something was rejected, if it was for missing pages, that's that. But you're saying the rejection letter was never sent to you, but you knew it was because of missing pages. I'm not sure how you knew that if you never got the notice, so that's kind of confusing. But if you just resubmitted it, that should be fine. But again, I didn't know what you resubmitted. I don't see your paperwork, so I can't give individual legal advice there. Paranoid says, if you charge a fee for every time you ask about timeline processing, you'd be a billionaire. That's correct. Actually, I have an assistant now, and I told her I don't have to read your questions. She picks the questions. And once 10, 20, 30 people ask about timelines and the embassies, how long they're going to take, she just does a reminder for me to say it at one time. Instead of before when I was doing the questions myself, I'll say it 50 times and it'll drive me crazy. So now I have more time to answer questions. So it's a good system. But thank you, Paranoid Droid. Paranoid Android. Prenom asks, does my brother need health insurance to get the immigrant visa? I applied for him 10 years ago. The requirement for getting health insurance before you get your green card granted was removed about a week and a half, 2 weeks ago. That aspect of the public charge rule was taken away. Now, embassy could always make up something and say they want that. But for now, if you file for your brother and the time comes, you just need to show you make enough money and just, you show that your brother is not going to come here and not be able to, support himself. It's a very low threshold. And so that's the rule right now. I wouldn't worry about getting health insurance or anything like that at this point, unless they change the rules by then. Dino asks, what documents to bring for embassy interview for a resident application? And then next question, Constanta, do you do fiancé visas? Yes, I do fiancé visas regularly. I prefer doing marriage cases. Fiancé visas have more complications and prices and costs, but I'll download the Ultimate Marriage Green Card Guide. It goes through the process, then email my office, schedule time. Go to www.marriageimmigrationlaw.com and download the Ultimate ebook on that. Now, going back to a question about embassy interview for resident application, it depends on what kind of green card application you have and your personal background. So to go over a long list, it depends on your facts. I can't do that here. But every embassy has a PDF they put out on the State Department's website of what documents they expect. And so you can go check that out. It's on the State Department's website for your embassy, and it'll list the different documents. Okay, and we're going to go to our end. Last couple of questions. Basirat asks, my husband filed for me, and we went for the interview in September. The interview went well, but the online status changed. The interview completed, but your case must be reviewed. We haven't gotten a response. So it's not good. September is a long time ago. September, October, November, December, January, February, March. Yeah, so it's not good. I don't know what to tell you. I don't know what happened. Sometimes the interview went bad. Other times, they lost something. You maybe want to write a letter to them. If no response there, contact your congressperson and say, hey, what's going on? You can file a lawsuit. But if it goes on more than 6 months, a year, they're probably doing a fraud investigation because they don't believe the relationship is real. And fraud investigation take years and years. So that's generally what's going on. Hopefully it's not that. Hopefully just get approved. But that's stuff I would think about. That girl follows up. How do you know if you should send form I864 or I864 Easy? Are they a must? Well, if you're doing a family-based case, typically you have to submit either of those forms. But generally, I864 is better. I864 Easy is a shorter, easier version to complete. But most times people submit form I864, the regular version, not the Easy, the smaller version who has less papers. Use the Easy if your income is like W-2 income, and it's more, the facts of your case are much more simpler. But because it's more rarely submitted, the immigration authorities have less experience with that form. And so I wouldn't risk that. I would just complete the regular I-864. I don't do the I-864 Easy for my clients, even if I can. It's better just do the regular one that they're accustomed to seeing. Sahad asked, hello, I had my marriage-based I-485 interview in Dallas location, Dallas field office, and we went to interview, but they said they don't have our documents. Is this something common? What's the next steps we can do to follow? So this is a really annoying situation that's happening more and more. You get an interview notice to go to your local USCIS field office for interview. Once you get there, they say, oh, we don't have your application package yet. We can't make a decision. I had that happen yesterday. I had a case, this is the only case that's for adjustment of status taking this long. 3 years. It's been pending 3 years. This is the easy open and shut case. Finally, after complaining for years, schedule interview, we go there. The officer says, well, I believe your marriage is real, but we don't have your file. So I'm waiting for it. They said they're going to send it in 2-3 weeks. After 3 years of waiting, should have been on 6 months, this case. And the client was frustrated. Like, what do you mean? How do they not have my documents? But you're dealing with the bureaucracy that has millions and millions of cases. It has all these issues. And so you have something like this. It's not common, but it does happen frequently enough. Depends on what your definition of common is. But I'm sorry that you have to go all your way, take time off work, your life, to go to an interview and then say, we don't have your documents, even though we scheduled an interview. That doesn't make any sense. But that's all I was trying to explain to my clients. They kept saying, this doesn't make any sense. I'm like, yeah, it's not supposed to make sense, but it's not the world. And so we just have to wait for them to get the file, hopefully follow up with them to hurry that up, but we'll see. Okay, Nixta asks, I received my I-693 deficiency notice. What am I supposed to do? The I-693 deficiency notice is, I-693 is a form for your medical checkup when you're applying for a green card in the United States. Make sure you don't have certain medical conditions. Once you file form I-485 adjustment of status, if you don't include it in the application, you'll get a notice reminding you about it. Now, if you have a case that's going to require an interview, they'll say on it, you should just read the notice. It tells you what to do. But it says, bring the sealed envelope of your medical checkup, which you need to do, and bring it to the interview and give it to them. However, if you have a case where they may not do an interview, the letter might just say, hey, mail it to us. Like I have cases of parents of U.S. citizens where if we don't send it with the initial application, they'll say, hey, mail it to us. So you got to read your notice and say, hey, does it say mail it to us or bring it to the future interview if they schedule an interview? And so you just got to read what it says there and follow those instructions, and that'll take care of it. Our last question. Thank you so much, everybody. Peter asked, I married my wife in a matter of 30 days of meeting her, but we've been living together for almost a year now and plan on applying soon. Is the fast marriage a red flag for USCIS? Well, it can be a red flag. USCIS has some internal list of like 10 red flags, and if you have 1 or 2 of them, it's not a big deal. But if you have 4, 5, 6, that becomes a big deal. I have filed several cases where people met a week, 2, 3 weeks after getting married after meeting within a few weeks, and they've been okay. We just have to show the totality of the situation. They do an in-person interview, fill you out, and it is approvable, but it depends on your case, and I have to really see you and make a judgment for myself how shady it looks or how realistic it looks. Try to accumulate documents, have joint lease agreements, property ownership, bank accounts, health insurance, life insurance in each other's names. There's all sorts of stuff you could do, but it is a red flag, but not necessarily a gain killer. It doesn't mean that you're not going to get approved. It depends on the whole picture. It's not the worst thing. All right, everybody, we'll be back again next Wednesday, 5 p.m. Pacific time for a regular Q&A session. Thank you for everyone joining 5 p.m. Pacific time. On Wednesdays, we do this all the time. Check me out on Instagram, JQK Law Firm. I have reminders there. One of my colleagues, my helpers, he puts some funny images of me to remind you. And if you want to schedule a private consultation, just email me at info@jqqlaw.com, and we can set it up, do a video consultation, see what's going on with your case. Until next time, have a good one. God bless. Be safe.